Everyone, thanks for joining us. We're going to be talking about the navigating Biden's new immigration policies, opportunities for spouses of U.S. citizens. Also, people are talking about it as for opportunities for mixed status families, because it also will help stepchildren of U.S. citizens. So this was announced, let's see, on June 18th. There was 2024. And this was given, there was a lot of hoopla beforehand. We'd heard maybe like a couple months before there was going to be something. We didn't know when or what. And then when I was at the American Immigration Lawyers Association conference in Chicago on the 14th, I heard there was something going to happen on Tuesday. And some information was being leaked, I guess, from the NPR. And then on the 18th in the morning of June 18th, 2024, we heard that there was the White House announcement, and then quickly there was the DHS announcement or sort of clarifying, and then there was the American Immigration Lawyers Association had come out with some information as well. So I'm really just going to give you some overview of what we know and what we don't know, I guess, and then ways to get prepared in the meantime. And so I'm Ruby Powers with Powers Law Group. I'm board certified and been in this space for more than I guess around 20 years or so as an attorney, 16. And we wanted to be a resource for the community and let them get prepared for this information. So Powers Law Group, we have a location in Houston and the Woodlands. And so basically we want to talk about what this new policy would be. It's not, let's clarify something though, it's not into effect yet. We're still waiting for a federal register to come out, and we're also estimating probably the end of August, end of August time, maybe early September. If you think about what happened with DACA, it was announced in mid-June, and then it went into effect in August. And so we think that that'll probably be very similar. It's the 12-year anniversary of DACA. And the other thing to note is that if you think about that time, they announced it, and like, was it June 15th, I believe, and then that you could start applying to 60 days later, like August 15th, I believe it was. There was also that whole announcement back in 2015 about DAPA, the Deferred Action for Parental Arrivals, and that got shut down. It's been a while. It's almost been 9 years, right? But I think a lot of that might have been because it was too big of a group. What this specific group is even smaller than DACA. It's only 500,000 according to their estimates, and 50,000 for stepchildren. So they announced a policy. Bottom line is they have the power, the executive power, to give parole, and Biden's been giving parole for lots of different things the last few years. And so part of the whole issue here is that in 1996, they had this law called IRA. And Congress thought they were geniuses because they're like, well, this will keep people from coming in because it'll create unlawful presence. Well, the thing is it actually sort of trapped people, if you will, because it said if you have more than 6 months but less than a year of unlawful presence. I created unlawful presence on April 1st, 1997. But then they said, so that was the beginning of that. And that's why it really matters when we talk to clients as to how long, when they came in, how long they were here. We have to get down into the dates and start looking at calendars, and it really matters. So what Congress said was with that IRA was that if you've been here more than 6 months, but less than a year, then you were, and you leave, you have a 3-year bar. And if you've been here more than a year unlawfully, then you leave, you have a 10-year bar. And then they even created this thing called the permanent bar, which can be triggered a couple different ways. But so you want to avoid that because there's really not a lot of good ways to overcome the permanent bar. So really what happened, it was the opposite effect. It's not that it kept people from coming in, it kept people from leaving. And there's been accounts of about 10 or 11, 12 million people who don't have status inside the country. And a lot of it stems from that, coming in and whether lawfully or unlawfully and overstaying. So this policy is supposed to help almost 500,000 spouses of U.S. citizens, about 50,000 stepchildren of U.S. citizens. And if you were to have this parole, there's this to be able to adjust status, which to get your green card, let's say, you had to be inspected, admitted, or paroled. Well, for a lot of folks, they entered without inspection and they don't have that legal entry, if you will. And so this parole that they're announcing could come live as early as a couple months from now, would give them that magic document needed to be able to adjust status, to do everything here inside the country. Because what we have to do at this moment is you have to have the spouse petition for you, you have to do the NVC fee bills, you have to submit the I-601A, which was created in March 2013 under Obama, which was great because before people had to stay out of the country while they were waiting for the waiver. So it was a family unity program. And so the provisional waiver has been amazing. We've loved it for the last 11 years. But unfortunately, for some crazy reason, the processing times have gone up to about 4.5 years on just the I-601A alone. So if this program were to go all the way into effect, which is it's an if, then we wouldn't really need to do the I-601A. But we don't know that. And this isn't truly live yet. And we're not sure if it's going to get struck down in some way. So what does it mean? You had to have had, we'll go into a little more detail, but you had to have been married to a U.S. citizen or have that qualifying relationship to a U.S. citizen on June 17th, 2024. And you had to have been in the U.S. approved that before 10 years before June 2024. So the benefit of a parole is that you can apply for work authorization. With a work authorization, you can obtain a social. And in the U.S., if you have a social, that's your social for the rest of your life. And you also, in some states that don't allow a driver's license unless you have status, this will allow people to get driver's license. So step one is obtaining the parole. And the parole will act as like that legal entry, if you will, or that meeting the qualifications for the adjustment. But it also, if all you can qualify for is just that parole, it'll give you can apply for a social, work authorization, driver's license. So it really opens a lot of doors. And then above all, if you don't have any other inadmissibilities that cannot be fixed with waivers, then you can apply for your legal permanent residency. So things we're telling people right now is to have a consultation to get screened for eligibility, to double check that they don't have a permanent bar, if there's any other issues like potentially misrepresentation, alien smuggling, criminal, those types of things. So really we're saying have a consultation for screening purposes and also start collecting your documentation. So, you can't submit anything yet, but things to consider, having any government issued ID. So if you don't have anything from the US, very likely, then, having a passport updated with your country, your birth certificate with English translation, your proof of your marriage and the status of your spouse. So proof of marriage could be your marriage certificate, license certificate, with the state, the status of the spouse, that could be naturalization or birth certificate. And then the proof of 10 years. Well, this is where it gets a little fun. How many documents do you need per year? We don't really know. If we were to take some of this, is giving me a lot of memories to DACA. It ended up being maybe 2 or 3 documents a year. So, I think they'll give us more guidance if it's something per month. That's a little bit too much, but I would say start collecting. This is probably going to be part of the hardest part because as time progresses, documents start disappearing. But these are things to consider would be like taxes if you have them, leases, birth certificate of kids, medical records, bank statements, those types of things. Now, I think the filing fee is going to be maybe around $630, but we don't know exactly. And also, this is going to be a case-by-case basis because it's a lot of discretion. One thing we don't know also is it does mention something about like good moral character and not have a public safety issue. That makes me think there might be a DWI being a restriction, but I'm not really sure. Because I think what we could do is assume something between the DACA requirements and the TPS requirements, somewhere in between there. With the TPS, you can't have more than 2 misdemeanors. With DACA, you can't have like a particular serious matter, and you can't have a DWI. But we don't know that. So that's the other thing. Between screening for inadmissibilities and a permanent bar, you also should collect your criminal records and any matters that you might have. So as we said, this is going to impact, if it goes all the way through, nearly 500,000 spouses, and then of course also their children, but also it could impact 50,000 stepchildren of U.S. citizens that for some reason don't have status already. So probably ones that might have been entered with family but didn't, weren't born here and weren't eligible for some other type of a status. So, there's been a lot of different attempts for some type of reforms. And DACA, you can't apply for new DACA right now. You can only renew DACA. There's a lot of different parole programs. And even the provisional waiver that came out in March 2013 was a great program. Now, we might have some challenges. This is a big issue. So, DACA was struck down, went all the way to the Supreme Court and up and down, but you can renew it right now. That's where it's at. And you can apply for advanced parole. So those are 2 good things, but we don't know the future of it. There's also DAPA was completely struck down, but I think that was a bigger group. And that now this one, here we go, for 500,000 people, if this were to be struck down, politically, it would be bad because those 500,000 American citizen spouses are upset that this program disappears. Well, they're a voting bloc. And so, where are they going to vote if this program gets struck down? So I think that was pretty smart on the way they were making this happen. So, things to consider, like we want to be a resource for the community. We're doing consultations. We're not working on a parole at this moment for anyone, but what we are doing for this parole, but what we are doing is screening, requesting FOIAs, helping do research, and just seeing who might be eligible from the details we have. Again, not all the details are out. That hasn't come out with the Federal Register at the time of this recording, which is today, June 26th. And but this can have a huge ripple effect, just like DACA did, and the provisional waiver it's had a major impact on a lot of other people throughout this. You can, like later on, if you can obtain residency, then you can get citizenship and petition for other family. So one thing I want to mention, there's some questions to think about. If you have already done the I-130 and your I-601A is pending, I think a question to ask is, how far along is your I-601A? Because if your process is further along, you might just want to finish it instead of doing this system. Again, because if you think about it, let's find out in mid-August what the details are that you can start applying. Well, we don't know how long the parole is going to take. Sometimes USCIS can be fast and sometimes it can be super slow. Is this going to take a year to get parole? Or is it going to take like a few months? If it's going to take a few months, then maybe it's worth it. But you have to have the parole approved before you can file the adjustment of status. So that's something to consider. I think if you were to ask me right now, I would say if you're farther along with the waiver and you might have already submitted the MVC process, you might want to just finish your provisional waiver process. If you haven't done absolutely anything, I'd say screening and probably filing an I-130 is smart, and send the I-130 to the NBC. Because if this program gets struck down, you at least have the I-130 pending. And if and even if it doesn't get struck down, you at least have the I-130 pending, because as soon as you get the parole, you could then submit the I-485 with the I-130 receipt, because you have an immediate relative. You don't have to wait for the I-130 to be approved. So that is what I think would make sense. But again, we're waiting for more details, and we'll do more webinars as we progress, get more details. So if anybody has any questions, feel free to put it in the chat. This was mostly meant to be informational, as with information that we have. So again, the parole, which we don't have all the details. We don't know what crimes will disqualify you. We don't know like how many documents you need per year to demonstrate. But we do suggest having a screening app consult and also collecting as much proof of those 10 years as possible. Once the information comes out to submit that information, you can't really do a lot until the parole gets approved. When the parole gets approved, you can also apply for work authorization if that's all you want to do, or you could decide whether or not you want to do the I-130 and the 45. There's one other thing that's really important to note. It's that it's about the permanent bar. So there's a lot of chatter going on the Facebook groups and other listservs and stuff. For what our understanding is, this is not solving the permanent bar. Like, it doesn't solve it for when you get military parole in place or anything else. So what might have to happen is that you just get the parole if you have a permanent bar, and you just keep renewing it if you can renew in the future. So, but at least that gives you work authorization, that gets you a driver's license and a social, which is better than nothing. I mean, again, it's still a decision on whether to stay in the United States, but there are some people who just keep renewing the parole, like military parole in place, for example, because they're not eligible for adjustment. So these are some of the things to consider. And I'm going to pull up some notes I had from a session yesterday. That there was a conference, a CLE, and I wanted to just sort of pull up some of the notes from that one. But does anybody have any potential questions? Feel free to either unmute yourself or put it in the chat. So these are some of the summaries. The application's not out. There's debate on whether we should file an I-130 while we're waiting. I think that we should, because at least probably what will happen is, for the people who haven't filed an I-130, then it's going to cause a little delays on the I-130 front. One thing we don't know an answer to either is are parole's going to be adjudicated all by one place, which I would hope, because then it's centralized, consistent adjudication, or is it going to be adjudicated like field office by field office or something like that, the way it is with military parole in place? Now there's 500,000, and it'll probably all be adjudicated like in the next couple of years if it goes all the way through. So I think that's one question I have. You know, the one thing that's also interesting to note is that in Texas we have common law marriage. So if you were living as a couple, calling yourself out to being married, and so on and so forth, you could backdate your common law, what's it called? What do we call it? The unofficial marriage. You know, there's only about 7 or 8 states in the country that have common law marriage. Texas is one of them. So you could go backdate your marriage to some date that you have proof that you've been together. Now, one thing to note is, if you haven't been doing taxes together and you backdate it to some date, like, you might have to amend your taxes at some point, but depending on if they give you a hard time about that. But it is something to consider, because we have a lot of clients who are not legally married but consider themselves married. If you have any things to do, I'd say, is if you have any criminal record, I would go collect that, get a police clearance record, or collect those records. Sometimes old things are hard to find. According to an immigration conference that was on yesterday that we got, so we obtained, we watched, and we have some notes. They're saying the average applicant is going to be about 40 years old and has been here in the U.S. since they were teens or 20s. And so, you know, the proof of presence is probably going to be a lot of like school and after school time. And a lot of people who don't have a social security number I've seen a mixture of either do or don't do taxes. So trying to find other proof. This is something that happened a lot during the DACA age. Some people just didn't have a lot of, they didn't have a lot of evidence of their status here. And so they had to work really hard to find that. And when I was talking about the common law registration, is the declaration and registration of an informal marriage. Thank you. So, and that's fairly easy to obtain. You can go down to like central courthouses and go with your spouse and register that. So, you know, it's very similar to what a military parole and police you show the requirements and then you wait for the parole and then you can apply for work authorization. And if you are not permanently barred, don't have any other major issues that can't be remedied with a waiver, you can adjust. And so, you know, what some of the notes of the prior webinar said is that this is essentially giving, giving the non-citizen an inspected admitted to the US and find a little bit of workaround from the I-601A NVC process. And because unfortunately that entire process has almost crept up to about a 6-year wait with the I-130 NVC waiver, NVC, and visa appointments. But not everybody's going to meet these qualifications. Not everyone's going to have been married to a U.S. citizen by June 17th. Not everyone's going to have been here 10 years. But this is going to, I think this is going to help some people who are dreamers, but couldn't qualify for DACA for whatever reason, like either, you know, no school, but maybe a crime or whatever it may be. So I think it's going to help catch some of those people. And yeah, I mean, we're just waiting for a little bit more clarity. And the stepchild is part of the announcement. There's not much detail. It's just more or less saying that they estimate about 50,000 children of stepchildren of U.S. citizens. When usually you talk about stepchildren, you're talking about children who that stepchild relationship existed by the time the child was 18, so before the child turned 18. So what we'd have to generally show for that would be the kid's birth certificate, English translation, the marriage certificate of the parents, and the U.S. citizens proof of citizenship, and also the parent citizenship being the parent. So, but usually show that with the birth certificate as well. So those are just things to consider, as well as everything that's not in English generally needs to be translated into English. So there's a lot of little homework people can be doing while they're working on these things. There's some little details about a 212D3 waiver to help those DACA students to overcome like unlawful presence. I think that's we can talk a little bit about that in another webinar. We're focusing mostly on the spouses and the stepchildren. There's expectation of a lawsuit to be filed against the program from the American First Legal, and arguments have not been clear, but a likely lawsuit will be had. And the other thing to consider, unfortunately, is if Trump were to win the presidency, I think this program would definitely go away, just like he tried to get rid of DACA and almost everything else. So anyway, that's why the way to adjust right now, or to legalize, I guess you could say, is through the I-601A program for people. I think at a very minimum, screening, like I said, collecting documents, and I would say do an I-130 to get that started. An I-130 petition for alien relative is taking about 1 year for spouses of U.S. citizens. And you can apply online, and usually online is a little bit faster than filing paper, and it's about $50 cheaper if you file it online. There's not a lot of details as to whether you're in removal or not, and there's a lot of different other questions to be had. So I think this more or less concludes the questions we have. If anybody has any questions, let us know. Source for you in the future. Thank you so much for watching.